Welcome you all to the second panel, EU Institutions and Agencies Challenges After Lisbon. My name is Joana Pereira. I will be the chair for this session. I work at the International Center for Policing and Security with Christian Kaunert, and it's my absolute pleasure to welcome you online to the center. Today, we will have a very esteemed and distinct group of speakers. First one is Dr. Ingemann Johansen, followed by Dr. David Fernandez Rojo, Professor Stefania Panebianco, Dr. Claudio Matera, and Jacob Öberg. I will introduce the speakers before they present their paper. And as such, I will start with Dr. Ingemann Johansen. So Dr. Ingemann Johansen is a postdoctoral researcher at the University of Southern Denmark. She holds a PhD in EU security governance from Roskilde University and MSc in political science from the University of Southern Denmark. Han has previously been a visiting scholar at the Institute for European Studies at VUB in Brussels. She has worked as a research assistant at the Center for War Studies at the University of Southern Denmark and served as a member of the expert network of the Horizon Fund, the CEVCAP project that focuses on the development of EU civilian capabilities for external conflict management. Her research is situated in the nexus between EU studies, security studies, and governance literature, and focuses on EU operational security policy. She researches the role and influence of different actors in the policy process and the effects thereof on security outcomes. It's my pleasure to give you the virtual floor, and you have maximum 12 minutes. Thank you.
Okay, thank you, Joanna, and thank you to Christian and Sarah and Joanna for the invitation to participate in this very interesting conference, and congratulations on the 3 Chamonix grants. It's very, very impressive. And actually the first time I met Christian and Sarah was also when you were awarded a Chamonix grant for EU summer school. So it's very nice to be here. So I will just try and share my screen. So my presentation will focus on FRONTEX, so the EU's Border and Coast Guard Agency, and it's entitled Mapping the Gap Between De Jure and De Facto Integration, FRONTEX and Joint EU Border Control Operations. See how, yes. So as many of you know, FRONTEX was established in 2004 with in order to help the member states of the European Union in the management of the external borders. And since then, FRONTEX has developed into the biggest EU agency of all. And with the 2 latest mandate revisions, it has also been delegated an increasing role in the operational management of the external borders. It has been granted its own standing border and coast guard. It has been granted operational powers, and it has been given a mandate to operate on the territory of 3rd countries. So in a sense, these developments are quite surprising, since the management of the external borders technically still is a national domain. So in this presentation, what I want to do is I want to examine the specific nature and scope of FRONTEX's role in the area of joint EU border control operations vis-a-vis that of the member states. So that is the type and degree of integration that has taken place within this field. And for this purpose, I asked the following research question: what is the nature and scope of European integration in the area of joint EU border control operations? And to which extent is there a gap between its de jure and de facto dimension? Yes. So the existing literature on EU integration offers several analytical frameworks for mapping EU integration within and across different policy fields, but they all tend to confine the analytical focus to the formal, so the de jure competencies that have been conferred on the main EU institutions, so the Commission, the Parliament, the Council, and the Court of Justice of the European Union, by primary law, so in the treaties, in relation to the political decision-making and judicial review in and across policy areas at large. So for instance, the area of freedom, security, and justice as a larger policy domain. And this is, of course, not of much help for the endeavor that I set it out to do in this presentation. So when you want to focus on a more confined policy area within a larger one, for instance, such as the instrument of joint border control operations, and also cases where the member states have delegated decision-making authority to an executive body such as FRONTEX. And also when we talk about secondary legislation such as an EU regulation, yes. So finally, they don't really allow for a complementary focus on European de facto integration. So one thing is what we read, but another thing is what plays out in practice. And then the role of supranational actors such as FRONTEX in other stages of the policy process. So in the article, I therefore set out to develop a generic analytical framework that can be also used to capture these varying aspects and forms of EU policymaking and in effect European integration. And for this purpose, I introduced the concept of a governance structure, which I defined as a set of rules, procedures, and practices that structure the planning, adoption, implementation, evaluation, and adjustment of a given policy. So I conceptualize this as the first dimension of authority, so the formal legal authority to do something, and a set of resources that facilitate and enable these activities, which is the second dimension of autonomy. And I argue that it's important to study both of these dimensions because they can have a condition and effect on each other. For instance, it's not of much use having been given the legal authority to launch an operation if you don't have any ships at your disposal, because then you're still very dependent on the member states. As you can see in this table, I not only distinguish between two different dimensions of a governance structure, but also three different levels. So the level of decision-making, the level of analysis, and the level of implementation. And this allows for a very fine-grained and granular analysis of the type of integration that has taken place within a particular policy domain. So I know you can't see this, but in order to also be able to distinguish between different degrees of integration, I use an ordinal 5-point scale that ranges from full supranationalism to no supranationalism, and develop indicators for a de jure as well as a de facto dimension. So the first table is all the de jure indicators, and the de facto table is the second one. And yes, I don't have time to go through all these, so bear with me. Then the research was designed as a single case study of FRONTEX Joint Operation Triton, which was launched in Italy in 2014 and continued until 2018. And in the case study, I rely on a within case comparison of the governance structures de jure and de facto dimension. While the first analysis focuses on the formal authority and autonomy that has been delegated to the EU in this area, the second analysis focuses on the actual authority and autonomy that was displayed by national and supranational actors in the case of Triton. And I rely on document analysis of public documents, internal working documents and statements, and then 15 semi-structured interviews with key actors having participated or having a privileged knowledge of Triton. And then observation from field visits to the International Coordination Center of Triton, the EU's Regional Task Force office in Catania, and Frontex headquarters in Warsaw. And in relation to the formal integration that has taken place, I find that on paper, Frontex has been delegated a lot of authority at the level of decision-making and analysis. However, this is counterbalanced by low degrees of autonomy at these levels, which keeps Frontex in check. And then that the member states had delegated very little formal authority and autonomy to Frontex at the level of implementation, where we still have a national command and control structure. And in terms of the actual integration that has played out in the case study that I focus on, I find that in practice, there's a very close cooperation between Frontex and the host member state at the level of analysis and implementation, where decisions are often evenly influenced by these actors, and that Frontex has low degrees of autonomy at the level of decision-making and implementation, but a high degree of autonomy at the level of analysis. And then the interesting thing, of course, is when we put this together, because then we can see whether or not there is a gap between the de jure and the de facto dimension. And what I find is that at the level of decision-making, the integration is aligned, but the central decision maker in Triton was not Frontex, but Commissioner Malmström, who formally doesn't hold any formal authority to decide on whether or not Frontex should launch an operation or not. That's a competence of the executive director. So even though supranational actors were as influential as we would expect, it's another supranational actor that was actually having the final say in the decision-making process. So there is a gap, but not in terms of degree, more in kind. At the level of analysis, I find that the member states in practice are more, or the host member state in practice is more involved in the policy planning and evaluation than we would expect from a de jure perspective. And then Frontex is in possession of more data, information, and intelligence, which are indicators of analytical autonomy than we would expect from a de jure perspective, given their high degree of expertise and or experience and level of expertise. So this makes them, puts them in a better position to plan and evaluate policy than we would expect. And then at the level of implementation, I find that Frontex has more influence at decisions, yes, at the level of implementation that we would expect from a de jure perspective. And these findings, I argue, are quite important and raises some very big questions in terms of accountability, especially in a time where we are seeing all these accusations of pushbacks and so on, where Frontex every time has said that at the level of implementation, all decisions are taken by the host member state. So yes, that's it.
Thank you, Anne, for this very interesting presentation. So now we have Dr. David Fernandez Rojo, who is a researcher and an assistant professor at the University of Deusto in Spain. His research focuses on the evolution of the operational cooperation and tasks conferred to the EU agencies, especially Frontex, EASO, and Europol. He's particularly interested in the impact of these agencies and operations in terms of the effective and uniform national implementation of migration, asylum, and border management measures adopted at EU level. David is also a key researcher in the German research network European Union Asia Pacific Dialogue, and he's also a coordinator at the University of Deusto for the Jean Monnet Network, EU law enforcement, and EU counterterrorism. He has conducted part of his research in the United States at the Washington College of Law and Georgetown Law Center, and also at the University of Utrecht. And prior to this, he specialized in European and international public law in the Netherlands at the Erasmus University, Rotterdam. Thank you, David. The screen is yours. Thank you.
Well, thank you very much, Joana. And first of all, excuse everybody my voice. I got a cold. The change of weather in Spain is kind of weird these days, so excuse my scratchy voice. Well, first of all, again, I would like to thank Joana and Christian and Sarah for this wonderful organization. It's very difficult to put together so many panelists and panels, and the organization has been excellent. So thank you for that. And it is a great pleasure for me to present because, as Joana said, I am the coordinator of this network in the north of Spain, in Bilbao, at the University of Deusto. So it is a great pleasure to present again under the framework of this network. So without further ado, I will start with my presentation. Let me share my screen. So today, what I'm going to be focusing on is in one of the conclusions that I reached on a book that it was published in January of this year, basically whether we are moving towards a supranational and integrated administration for the European area of freedom, security, and justice. Here is the reference of the book, and there's a short summary of it in the EU law analysis blog. So what I do in the book, and I'm not going to do it today because for the sake of time, but what I do is I analyze the evolution of the operational tasks conferred to three agencies, to FRONTEX, EASO, and EUROPOL, throughout the different treaties. And today what I will be focusing on is basically on the Lisbon treaty, and specifically what happened after the so-called refugee crisis of 2015-2016. So for those of you who are not familiarized with this, in the whole institutional landscape, what I'm focusing on basically is what it says there, the EU Justice and Home Affairs agencies. So basically, what happens between the implementation of the laws that are adopted and the implementation and enforcement of these EU laws by the member states. And I analyze the operational role that the EU Justice and Home Affairs agencies, in particular Frontex and EASO and Europol, have to play in this regard. So without further ado, what I do basically, what I analyze in order to reach this conclusion that we are moving towards an integrated administration at the area of freedom, security, and justice is the transformation of Frontex into the European Border and Coast Guard, the transformation of EASO, the proposed transformation, because it hasn't been adopted yet, of EASO into the European Union Agency for Asylum, and basically also the role of Europol, and in particular in regards to one crime that is the migrant smuggling. So if we start with the Migrant Smuggling Center that it was established by Europol on February 22nd of 2016, Europol decided to launch this European Migrant Smuggling Center that focuses mainly on supporting the member states in dismantling criminal networks involved in organized migrant smuggling. This center has 5 main areas of action: providing operational support, strategic support, also a platform for coordination between the states and the partners, supporting the European Union Regional Task Force at the hotspots that were established in the aftermath of the refugee crisis, excuse me, and the deployment on the spot, well, what we refer as the Europol mobile investigation teams and the Europol mobile analysis teams. I leave there a graph in which you can see the importance of the operational support of Europol on the ground, and in particular of this migrant smuggling center. If we think about Frontex, Frontex was established in 2004, but today what I'm focusing on mainly is the transformation that they had in 2016 with adoption of the regulation 2016-1624, and in 2019 with adoption of regulation 2019-1896. I cannot obviously focus on all the different transformations and new operational tasks that were conferred to Frontex, so I'm focusing only on one, just to give you an example. That is, since the adoption of regulation 2019, Frontex, now referred as the European Border and Coast Guard, is going to be able to subject to the authorization of the member state that is hosting a particular operation, is going to be able to conduct operational executive powers so important as verifying the identity and nationality of the arriving migrants, authorizing or refusing the entry upon border checks, stamping travel documents, issuing or refusing visas, etc. Executive tasks that used to belong to the core national powers of the states. It is true, and I say there, that although these executive powers may ensure a more effective, integrated, and supranational administration of the European external borders, these activities entail a significant and difficult to control degree of discretion, and this is something that I also analyze in the book. Similar thing in regards to EASO. EASO was established in 2010. And there was a proposal again to transform the EASO into the European Union Agency for Asylum. As many of you know, due to the blockage on the asylum package, the European Union Agency for Asylum regulation has not been adopted yet. However, again, just focusing on one of the main operational tasks, the main operational transformation of these agencies, that the European Union Agency for Asylum is going to be able to examine asylum applications. So the European Union Agency for Asylum, according to the proposal, will be able to carry out the admissibility and substantive interview, assess the evidence, and prepare decisions on applications for international protection. Again, we are talking about core national sovereign tasks that are conferred to the states. So we are moving towards this integrated administration in a way. Again, just in a graph, since I don't have much time, but another thing I do in the book is to analyze a novelty, the multilateral cooperation on the ground on the hotspots, and in particular in the Italian and the Greek hotspots. As you know, in the aftermath of the refugee crisis, these three agencies, and Eurojust and the FRA also, but I only analyze these three, they are deployed on the ground and they provide direct assistance to the Italian and Greek national authorities. And they are coordinated in what we call the EU Regional Task Force. So with this very quick overview, what I try to show you is that we are moving towards this supranational administration of migration, asylum, and border management. Nowadays, the tasks of FRONTEX, EASO, and EUROPOL in regards to migration, asylum, and border management matters, they obviously have a clear operational nature, excuse me, on the ground. These agencies are obviously increasingly involved in guaranteeing the effective and uniform implementation of EU migration, asylum, and border management measures, as well as ensuring that the member states do not jeopardize the functioning of the Schengen system and the common European asylum system. So that's why I argue that the long-standing notion of administrative and implementation power in the area of freedom, security, and justice is shifting. What was the traditional approach? The traditional approach is that we have EU laws in terms of the area of freedom, security, and justice that they are adopted, and then the states are the ones that are basically in charge of exclusively implementing and enforcing these laws. However, the Commission after the refugee crisis saw that there was not a problem of adopting EU laws, but rather ensuring that the member states are effectively and uniformly implementing these laws. So that's why FRONTEX, EASO, and EUROPOL are increasingly steering and shaping the effective and uniform implementation of EU migration, asylum, and border management laws and policies at the national and local level. For those of you who are more visual, you have this same explanation in this graph. So we are moving from technical assistance and member states implementation towards more EU implementation and more operational tasks with a different transformation of Europol, FRONTEX, and EASO. So just to conclude, it is true that the Commission keeps referring to fully fledged European Union Agency for Asylum, fully fledged European Border and Coast Guard Agency. But it is important to notice that taking into account the treaties, taking into account the Meroni Doctrine, these agencies are neither conferred decision-making powers nor executive or enforcement tasks. It is true that they are increasingly, these agencies, steering and monitoring policy implementation. They are reinforcing the operational tasks that they have on the ground in order to support directly the states. And this is very important. This is something I analyze throughout the whole book. This will be de jure the situation in the future, but we have to pay a close attention to what these agencies do de facto on the ground, because we have seen a gap between what they are supposed to do de jure, because the regulations are very open in terms of what they are supposed to do and what they actually do on the ground when they're supporting the states. And we have to see whether we have enough accountability mechanisms to control what the agencies do on the ground, because these agencies are different. We have to remember this, these agencies may affect directly or indirectly the fundamental rights of the individuals, and also they are affecting, touching upon the core national sovereign powers of the states. Anyways, these three agencies, and in particular Frontex and EASO, they reveal how difficult it still is to strike a balance between designing an effective integrated strategy for the management of migration and asylum and the member states' resistance, reluctance to confer operational powers directly linked to their core national sovereignty. Thank you very much for your attention, and excuse my voice again.
Thank you, David. Perfect timing and very pertinent questions, especially regarding accountability. Next, we have Professor Stefania Panebianco. She is the holder of the Jean Monnet Chair, EU Mediterranean Border Crisis and European External Action. She's also an associate professor of political science at the University of Catania. She teaches Mediterranean politics and institutions of global trade at the University of Catania, migration politics, and in the Mediterranean at Luis S. in Rome. She's also a visiting professor at EBA, University Pompeu Fabra in Barcelona, and she's the co-editor of Global Affairs, author also of the monographic book L'Unione Europea, Potenza Divisa nel Mediterraneo, and articles for Third World Quarterly, Geopolitics, Contemporary Italian Politics, Journal of Ethnic and Migration Rules, International Politics. And finally, she's also a researcher within the PROTECT Consortium, an Age 2020 research project for the next 36 months. And her main research interests lie on the Mediterranean migration, EU foreign policies, and EU-MENA relations. The screen is yours, Stefania. Thank you.
Thank you very much, Joana. I wonder if you can see the slides that I am sharing.
Perfect.
Yeah, that's okay. Thank you very much, Joana. Before I start, please let me say that I have appreciated very much all the efforts that you have done in order to put together this fantastic, excellent program. And Professor Christian Kaunert and Professor Sarah Leonard are always organizing challenging and timely events. These 3 days of conferences for sure will represent a milestone in the advancement of literature, academic studies, but also fruitful exchange of views with experts. Then congratulations for this conference. As Joana has already mentioned, the presentation that I am going to share with you is part of large project which is called PROTECT, which is an Age 2020 program funded by the European Commission. And as a member of the unit here in Catania, I have been tasked, I started researching on the European Commission and the discourse of the European Commission that ended up with the adoption of the new Pact on Migration and Asylum last September. And I have started researching the question, what has changed with the COVID-19 crisis, if ever if anything has changed with the COVID-19 crisis in the Commission's discourse, but also more in general in the European Union attitude and discourse on the migration issues. This presentation draws mainly on an article that I have recently published for the International Spectator that is free to be downloaded because it's published in open access thanks to the generous investment of the H2020 program. And this represents, in my opinion, the first step of a longer research, because in this paper, this article, I have investigated the discourse of the European Commission in particular, but now what comes after is to see to what extent what the European Commission has said, has claimed, and has clearly identified in its discourses will be turned into policy initiatives, into specific new policy initiatives. Now, let me start from the beginning. That is to say, when I decided to invest in this research. Well, last year, I think that most of us were very much impressed by the effects of COVID-19, and I was very much intrigued by the way how the COVID-19 has entered the research agenda, taking into account vulnerables. And when I say vulnerable people, I have in mind, of course, irregular migrants, because this is my main research interest. And what has been clear from my research is that it's not just for governments that COVID pandemic has raised unprecedented challenges, but also for individuals, also for civil society at large, and in particular for people who live at the outskirts of society. That people live in the irregularity, that people have been forced to be people on the move, most of the time because they had decided to, but they were forced to, and have remained blocked, almost kidnapped in areas of irregular parts, being irregular individuals in areas of EU member states. Well, I think that you might be on the same line as me if we think what the European Union has said last year. In 2020, there was a sort of clear leitmotif of EU institutions. The European migration policy had to be relaunched. There was this common frame that the European Union, I think about President Michel, I think about the President Sassoli, the presidents of the institutions were continuously claiming that a new European migration policy was really needed. But then, let's see what has happened. On its hand, the European Commission's discourse on migration has acquired a specific humanitarian dimension. And the research that I have conducted, of course, within the framework of discursive institutionalism, has clearly demonstrated that there was a consistency on the part of the European Commission to talk about human and humane approach. Well, actually, this human and humane approach is not bluntly new, but it was, if we think, for example, about the humanitarian approach that the European Commission had already expressed in the EU European Agenda for Migration of 2015. But what was new? It was the redundancy. It was the focus and zooming on human beings and human security, on vulnerables, on irregular people that have to get away from this limbo because they deserve health insurance, good conditions, what the European Commission considers a human and humane approach. Then it has to be seen if the European Commission will be able to turn this discourse into a real policy change. The research questions that I have raised and addressed in my paper are the following. Has the COVID-19 crisis refocused attention within the European Commission on human security? Yes, clearly there has been a continuous reference to irregular migrants, even in documents, in the 20 documents that I have analyzed that are listed in the article. Well, it's clear that irregular migration is not just one topic of interest in the documents, which are focused primarily on migration, but it is an interest and a focus that emerges also in documents related, I don't know, on financial crisis, on Brexit, and therefore it's a recurrent interest of the European Commission. And when I say European Commission, of course, I do not have on in mind the President of the European Commission, even though it's huge what President von der Leyen has done in order to attract the attention of the other EU institutions on the need to focus on human security. Of course, I have in mind also the vice presidents, and particularly Commissioner Johansen, who is continuously claiming that time has come, time is now ripe for a new European governance, migration governance that takes into account the human beings' interests and needs. Second research question, has the EU institutional discourse on migration of the European Commission in particular developed a distinct humanitarian approach during the COVID-19 crisis? Well, actually, the answer is yes on the one hand, in the sense that it has profited of this window of opportunity to relaunch interests and ideas that were probably already in the agenda and that have found a new place in the policy making due to the COVID-19 crisis. Because the idea that clearly emerges from documents is that if we want to achieve and acquire state security, then human security is needed. Then it is by providing human security that state security is provided in the documents that I have analyzed. Third research question, how and to what extent the European Commission has endeavored to promote policy change, well, clearly and consistently, although again, the follow-up will tell us to what extent a real policy change will take place. Okay, I will skip the theoretical approach, considering that I don't have much time, but let me jump, not even the methodological note is necessary, but I want to stress that in line with what Vivian Schmidt says, considering and taking into account ideas, the entire article stresses the fact that ideas count. And President von der Leyen, Commissioner Johansen do claim consistently on human security. And what is really interesting is to see that the passion that this speaker or the institutions do attach to the need to take into account migrants' needs is to be taken into account and to be considered. Then ideas, values, and principles have, I cannot say have entered again the agenda, but are there, and they are part of this discourse in time of a pandemic. Then my warning is the following. In order to conclude, what I want to share with you is that in the article there is the analysis of discourses. I do invite you, if you so wish, to have a look at the article. I don't have time. I don't want to analyze the discourse analysis, not even get into the details of the cloud that I have generated, but please let me conclude with the following statement. If we open the black box of the EU policy making, we can have a clear idea of what is taking place at European Commission's level. We are perfectly aware that when dealing with migration, it's the state governments level that count, and it counts as individual EU member states and also as European Council, and also as Council, because it was the Council that has stopped, for example, the reform of the Dublin regulation. Then we are perfectly aware of that. But the European Commission is trying to play, even when dealing with migration, the traditional role of policy entrepreneur. And this research has zoomed on a traditional role that the European Commission has played in several policies. And even in this case, we can talk about this role. Then if we open the black box of the EU policy making, we realize that the European Commission has elaborated programmatic discourse. It's not just to provide coordination among EU institutions, that the European Commission is listing the shopping list. It's to, again, envisage the vision for the future, that the European Commission is identifying the goals and the objectives to be achieved. Now, as my last line says and suggests, since intergovernmental challenges are around the corner, when we move further from here, then my first research objective is to see what will happen to the new pact on migration and asylum. And in the first session this morning, already several problems related to returns have been identified. Then the H2020 Protect research program is trying to realize to what extent international protection is still guaranteed. Or conversely, EU member states are challenging and risking the international protection. The intergovernmental statement, even in the literature, has been identified as a risk, and I'm perfectly aware that there still is the risk, as it happened with the Dublin regulation, but also with the relocation quota system that was blocked a couple of years ago. Thank you very much. Looking forward to the debate.
Thank you, Stefania, for your presentation. It has lots of questions that is also related to mine, so I look forward for the discussion as well. Next, we have Dr. Claudio Matera, that today is also acting as our discussant, because unfortunately, as you have realized, Professor Sarah Leonard, she's a phonic, she's very sick and she cannot speak. So I welcome Dr. Claudio Matera, who is assistant professor and chair of international and European law and governance at the University of Twente. His research focuses on the EU external relations in the field of justice and home affairs, and his publications address both substantive and institutional issues. He's a member of ECLAN, an associate editor of European Papers, and a member of the editorial board of Questions of International Law. And prior to joining the University of Twente in 2015, he worked as a research fellow at the TMC Asser Institute. Between 2011 and 2015, he cooperated with ICCT in Den Haag, and he has worked as a researcher and a consultant on EU counterterrorism law and policy. Finally, he has cooperated with CLEAR since 2009, and his publications include the external dimensions of the EU area of freedom, security, and justice, a constitutional perspective, and international organizations in the area of freedom, security, and justice. The screen is yours, Claudio. Thank you.
Thank you very much. Good afternoon, everybody. I hope that the whole system will not fail me. Thank you very much for the invitation, and congratulations on getting to organize the funds to organize this very interesting research program and this conference to all of you. Today I will present an adopted version of the paper I presented at the conference, the EU and International Affairs, that was held, let's say, digitally in Brussels about a month ago, and it's an adaptation of a chapter on the external dimensions of the AFSJ that was published in a book on EU external relations law. And I try to adapt this to the purpose and the theme of this conference. So I limited myself to trying to get 3 points out of this presentation today. One, where I will try to discuss how the external dimensions of the AFSJ emerged. One, discussing how the EU affirmed its actorness in external affairs. And a third point, in which I try to highlight some of the unsolved challenges or questionable choices, if you want, that have characterized this peculiar field of EU external relations. Inevitably, as a lawyer, there is a tendency of speaking more about competences and power to act, but I will try to use as many examples as possible to support and present my findings. So the early days, I think that inevitably to talk about this, I need to start with the early days of the externalization of the AFSJ, because of course, back in the late 1990s, I mean at the time of the Tampere conclusions, and since then, the development of the AFSJ as a whole, but of course also of the external dimensions thereof, was characterized by programmatic documents. Now, a lot was said about the process, the actors involved, the process dominated by the member states, of course, qua European Council, and a lot was said about that way of shaping policies, and notably what in academic publications was emphasized was how the executives were setting the agenda and influencing lawmaking and substantive choices in an unprecedented way if you'd compare the AFSJ to the internal market. But another thing that emerged is, of course, that there was an instrumentalization of external policies to build the AFSJ. And so the priority of the relations of the EU with third countries and international partners was presented as a way to legitimize the internal building of the AFSJ. And to some extent, I think we can see that still today, because when the Commission launched the e-evidence package, it included together the e-evidence internal proposals with the initiatives to conclude an EU-US agreement on e-evidence, and asked and decided on the accession of the EU to the second protocol of the Cybercrime Convention, which is on e-evidence. So there was this very high instrumentalization of AFSJ policies, and at the time, the Council was setting the parameters on the basis of which external interactions were supposed to be sought and concluded. So in a manner so as to justify, in a way, the development of this policy, we had a relatively certain and relatively accountable framework through which we could assess, analyze the developments on the external dimensions of the FSJ. And of course, this is highly complicated because pretty much like the internal market, the AFSJ is an expression, an idea, policy field, which makes no sense whatsoever outside the EU integration process. And therefore, the programmatic documents were very helpful in this regard. One, however, shortcoming of this process was, of course, that it was dominated to a large extent by the European Council. And in spite of some of the changes that were adopted, especially around the time of the Stockholm program in 2010, there was little to no HR and data protection strategy in those documents. And I say this because, of course, apart from general reference to upholding and promoting EU standards in cooperating with our partners, there was no clear indication of how that was supposed to happen, with the inevitable outcome that oftentimes the standards were neglected, forgotten at the time of concluding an agreement. So an interesting way of developing EU policies that, of course, was also codified in Article 68 of the Treaty on the Functioning of the EU with the entry into force of the Lisbon Treaty. Again, giving the executives, and perhaps as a way to further codify Article 72 and Article 4, where the treaties protect the prerogatives in terms of public order of the member states, but a further way to control the policy development there. In these formative years, pretty much like the sorrows of the young Werther of Goethe's book, we had quite a mixed bag of results. So from one side, we have seen that quite interesting experiments took place. Instead of the usual debates on exclusive and shared competences, the actors involved, and especially so the Council, managed to shape and develop new forms of external relations for the member states or for the EU, depending on the perspective. I think of the local border traffic regulation and regime, the different types of agreements, such as the mutual legal assistance agreements with the US, or the participation of the EU into private international law conventions, where the EU takes the lead on the basis of an internal act and a special mandate of the member states, or vice versa. The EU empowers the member states to act externally, so concluding agreements with partners and international organizations, but by restricting their autonomy, i.e. dictating the substantive clauses of what the member states can negotiate with third parties. So there were some really interesting developments occurring in this context, but at the same time, there were some issues that were not addressed. One of them was, of course, an issue of substance and content related to human rights protection standards and data protection standards, I don't need to mention SWIFT and PNR sagas that also will be addressed directly or indirectly in the next days here. So truly a mixed bag, but a clear emergence of the EU actorness in this field at the time. If we look at these developments now in 2021, so looking almost at 22 years of this process, what can we infer? And again, I don't see much of a change in the sense that we are witnessing another Echternach procession for the EU integration process and EU external relations. So for each 2 steps forward, we take some steps backwards. One thing that we have noticed is that the EU has managed to streamline, as since Tampere wanted to do, AFSJ clauses in broader external relations tool. A good example of this is Article 26 of the EU-Philippines agreement, where also the court recognized that we can have readmission clauses in development cooperation agreements, even though development cooperation is supposed to primarily address the eradication of poverty. But this is not the issue. The issue is, and this is perhaps also something related to some of the observations that preceded my communication, this is particularly related to a problem of content and value of these clauses. The clause with the Philippines agreement says that the Philippines shall readmit not only any irregular Filipino citizen residing within the EU or present in the EU territory, but they should also readmit any third country national that entered the EU via the Philippines. And what is problematic in this regard is understanding the extent to which this type of clause actually binds and further restrict the autonomy of member states and third countries in applying and enforcing the agreement. So this is a question left open. Most people would say that these clauses are not self-executive, of course, but when they operate in a vacuum, then they pose problems because potentially there is an affectation of individuals in this regard. Another problem, of course, that has emerged is the coordination of readmission agreements at large. It is still not clear, and the substantive clause has been approximated, but only to a certain extent. It is still not clear how the EU is proceeding and what the value of these clauses always are, and the extent to which then member states have autonomy when they conclude bilateral enforcement regimes with third countries. And another substantive difficulty is, of course, the one related to substantive clauses related to data protection and human rights. Again, there's plenty of opportunities, I think, for others to get into the details of this. But we know that systematically the court, when it comes to data protection, has brought down a number of agreements concluded by the EU. Personally, I also have some specific point of concerns in relation to the developments that are occurring in this policy field. The first is the blurry lines between the common foreign security policy and the AFSJ. We are witnessing both a militarization of some sort of migration policy and human trafficking control, which is very problematic. Let's think of the swift switch between Sophia and Irini operations, but we also saw that with the piracy case, which the court framed, and the anti-piracy agreement as,
Claudio?
yeah, almost finished.
Yes, I would, yeah. You have
I know this
2
is the
minutes
last
over.
part, yeah.
Okay, thank you.
As I was saying, where the EU has concluded an extradition agreement, which for many states is constitutionally restricted to an agreement that must be passed by parliament, whereas the court in the EU context recognized that the executives can conclude extradition agreements without the direct involvement of the people's representatives. All in all, and this is really the last sentence, what I'm trying to say, and I'll move to the last slide, is that the AFSJ has been a laboratory. But whilst for some instruments we have seen the EU institutions operating out of the box, we have seen also in the examples I mentioned and the Turkey EU statement, which has also been covered, we have seen the institutions thinking out of bounds. And this opens a number of questions when the EU affects the rights of individuals and in terms of accountability of the institutions. And thank you for your attention.
Thank you, Claudio. Finally, we have Dr. Jacob Öberg. Jacob, he's an associate professor of EU law at Örebro University. He holds a PhD in European law from the European University Institute in Florence. And since then, he has been a senior lecturer at the Örebro University. His research has addressed a variety of topics in the areas of EU constitutional and criminal law, including the federal dimension of EU law, judicial review of EU constitutional principles, EU criminal policy after the Lisbon Treaty, and legitimacy and justifications for EU legislative action. He recently acted as a sole guest editor for a special issue with the Maastricht Journal of European and Comparative Law. He's also a member of the Scientific Committee of the European Law Journal and the steering group of the Swedish Network of European Legal Studies. Additionally, he's a peer reviewer for the Journal of Common Market Studies, European Journal of Risk Regulation, and European Law Journal. His work has been widely cited at the European Parliament, and he has been involved as an expert on EU law in larger consultancy projects for the EU Commission. So the screen is yours, Jacob. Thank you for coming.
Thank you very much, Joana, and I'm delighted to be here. Really, it's wonderful to be invited for this event, and it's a great event with a number of interesting presentation, and it seems like a really nerdy also event for people really interested in EU criminal law, EU criminal justice agencies, AFSJ. So it's the perfect place to be here. So I'm going to try to summarize and also develop a bit of my recent work on EU criminal law. And I'm going to share my screen now. And this presentation is based on an article I co-authored with very much with Christopher Harding, now recently published in Maastricht Journal of European Comparative Law. But I'm going to kind of confine myself because I know there is a time limit to criminal justice agencies, because I think that's what most of this panel is about. And I think my presentation fits very well into Anne's presentation and David's presentation. They're very closely related in many ways. So I'm going to look at the broader question. What are the justifications or drivers for policies in the area of EU criminal law and EU criminal justice agencies in particular? What and why? Also, I'm going to talk a little bit in the end about why should we have EU criminal justice agencies at all? I think that's a kind of important question to ask here. So the idea is to look at and take us back to kind of traditional sort of ideas, the different arguments that we have been able to kind of extract when we looked upon this. Chris and Ivan wrote our paper. We looked on the two different kind of arguments that we think were kind of like played out by EU policymakers, by the Council, the institutions, the Commission and the European Parliament. And one is the supranational argument, and the other one is a kind of more intergovernmental justification, which is related to security. And based on that, we try to make a correlation, and we try to kind of like make some conclusions overall of what are why specific institutions are making specific arguments for EU policy development. So this is really a broad kind of paper. I'm not, so feel free to interject and object to a lot of things that I'm saying, because I'm generalizing heavily here in this presentation. So what we found when we looked on this, and we took some examples from this, is that we saw a correlation between the justifications used, as I was already saying, between certain developments in law and policy and the players involved in shaping those policy. And I'm going to focus here on European Public Prosecutor, Europol, and Eurojust. And if we look at the European Public Prosecutor, which is perhaps I'm closest to my heart in many ways, we can see that the justifications has been very instrumental, and it's been triggered and developed and very much driven policy forward by supranational EU institutions as the Commission. Of course, academics has been involved in over 30 years in developing this project, but the Commission was already from the start on this project. Why? Because here we're dealing with a kind of specific supranational interest, the protection of the EU budget, the EU's financial interest. So we see the supranational institutions have a much larger influence in shaping the development of this agency. Of course, member states were saying a lot of things as well when the Commission actually proposed this after Lisbon, but still, it's very much driven by the Commission as kind of the agency here. Which this can be contrasted if you look at the European Public Prosecutor to the other criminal justice agencies such as Europol and Eurojust, where we can see the development. I know that Christian Kauner touched upon this already in introduction, but this really goes back to the sort of developments in the mid-90s of the EU having to deal with this kind of collective action problem of transnational organized crime, but which really was triggered more, this development by these agencies, by the 9/11, the terrorist attacks, and all of this really driven towards a very security-oriented rationale. Is member states who have been in very much charge of both these agencies, how they were developed. The Europol was developed very much as even as an intergovernmental convention from the beginning. So very much the member states driving this project forward. After Lisbon, we can see that the EU institutions and the Commission and Parliament are much more involved, but this has been much more like driven by member states, but also been driven by this kind of overall idea of providing sense of safety to citizens, security, very using these agencies in a bit of more expressive way. And I mean, I know that I generalize enormously here. I know that this can be attacked on many different points, but it's just to see if my overall arguments stick together here. So if these are kind of the sort of the general descriptive account for how the justifications have been used in this development of law and policy, I also want to think about why should we have this? What justification should we have for having EU criminal justice agencies? What should be the drivers of policy? What are the normative sort of like justification for EU criminal justice agencies? And here I'm kind of like touching a bit on not published work and things that I'm doing in the future, but I have some ideas where I'm going with this project as well. So why should we have EU criminal justice agencies? Well, I think we should have them, actually. I'm going to be honest to you, to touch this normatively. I think we should have them because I think they are, we can confer powers to these agencies to kind of address problems arising from transnational organized crime. And this is based on a kind of long line of work theories, legal theories, political philosophy, but based on the theory of transnational interest, where both economic rationales, we have a lot of expertise, we have a lot of resources, we have also different incentives on the EU level to tackle transnational crime. And particularly when it concerns like real kind of supernatural interests, such as the EU budget, the incentives for the EU criminal justice agencies is a lot stronger and more clarified than when it comes to national criminal justice agencies. And we can see that also that Europol and Eurojust, although they have not been conferred with very strong formal powers, have been very successful in terms of coordinating, in terms of gathering information, in terms of like knowing where to best develop a criminal investigation. So I think there is rather a case, and this is, of course, member states is going to be very skeptical about this, but there is a good case, I think, normatively to extend the mandate of Europol and Eurojust to deal with transnational crimes and to give them more formally binding powers to commence investigation, to start investigation, to coordinate investigations, to force national criminal justice authorities to do certain things. I think this is actually what, so based on this theory of transnational interest, I can be an EU skeptic, but based on this theory, I think there's a good case for extending the powers of Europol and Eurojust in particular, perhaps also the European Public Prosecutor. Let's see, it's already now started to operate, so let's see how it goes. But I think there is a good, so I think this is where I kind of like want to go in the future with my research on this, because I now done a bit of like the descriptive part, trying to understand the justifications. Also, I looked a lot about competences and all that, but we also have to think about why should we have these agencies? What are the added value of them as academics as well, I think. So to summarize a little bit here and to recapture, I think that in terms of the European Public Prosecutor, we can see that the traditional sort of effet utile, the function rationales for development of supranational EU policy has been transferred to the European Public Prosecutor. It's about enforcing a specific EU policy. It's about protecting a very defined specific EU interest, which is the budget. So there's a very strong, this has been driven policy forward. And because of that, there's also been supranational EU institutions, which has been driving law and policy forward very much, particularly the Commission. In terms of Eurojust and Europol, we can see it's more the member states who are have been managing this over time in different ways, very much in the beginning, maybe less so now after Lisbon. We see a stronger presence by the other supranational EU institutions, and maybe also stronger independence as well, autonomy. If we go back to that, what Anne was speaking about, a stronger autonomy by Europol and Eurojust over time. But still governed by security and concern for safety of citizens as kind of the general kind of backstory. What I say in the future, I think we should have EU criminal justice agency. This is rather a strong case I'm going to make in the future, in my future article for this, because I think there's a complex transnational criminal activity. It should circumscribe the scope for EU intervention, but it also justifies EU intervention in the field of operational cooperation, this theory of transnational interest. So thank you very much for having me here, and I leave now to Joana.
You still had 1 minute and 40 seconds.
Yeah, I know. I'm really fast talker, very fast talking.
Yes. So as I mentioned at the beginning, so Professor Sarah Leonard was unable to be the discussant today, and Claudio Matera volunteered to be the discussant as well. So I give him the floor, and then I will open the Q&A. As we have 56 participants, I think it's completely plausible to give them the live floor. So if you want to put your questions, you can raise your hand, and then you can use your microphone to put your questions live. So Claudio, now you have more or less 7 minutes to discuss. Thank you.
I think I will, thank you very much, but I think I will keep it short.
Yeah.
Not because the presentations were not interesting, but because of my limited time to get a sense, a deep sense of them. but I think we can draw some conclusions. And I think that one is a relatively recent publication of the Center for European Policy Studies on the 20th anniversary of the Tampere conclusions was discussing the difficult balance between protecting citizens' interest and having a more global consciousness on freedom, rule of law, and human rights. And I think that this panel represents quite well the dilemmas that were characterizing the EFSJ since its beginning. We have seen in this regard a number of very interesting things, and more technically perhaps, the dilemma concerning what is the scope of Article 72 and this clause in the treaties that protects the sovereign prerogatives related to security and public order of the member states. Because I think that what emerges from the discussions and the presentations we've just had is that if the AFSJ was initially conceived as a normative hub that was supposed to put together, bring together the national systems of the member states, what the different presentations suggest is that in order to effectively answer to the call on the protection of citizens that still characterizes the FSJ on the one hand, and uphold also the obligation to respect human rights and rule of law standards, what emerges from the presentations is perhaps that a bigger, stronger role for the EU should emerge. I thought that it was, starting with the first presentation by Ingemann, I thought that it was remarkably fascinating how, in terms of implementation, there was this result concerning both the implementation and the analysis concerning the different roles of FRONTEX and the member states. And what is very interesting to note in that regard is, of course, from also the presentation she gave, is the difficulty of correctly framing the spaces of the national administration and then the responsibility for the operationalization of the policies and strategies. And I wonder, on the basis of her presentation, if she gets a clearer picture of what the concerns in the attribution of more powers to FRONTEX are. Is it a consciousness of the risk related to responsibility? Is it administrative and bureaucratic hurdles? What is the missing point there? Because, of course, from the operational point of view, we have seen that member states have not the sources oftentimes to react to the emergencies. Another point that came up related to this was in the second presentation by David Fernandez, where he, I thought fascinatingly, gave us many examples of how agencies have acquired more operational room. And I wonder what perhaps in 20 years we will teach to our students that the EU can actually arrest you if you misbehave, something that up until this moment, we always say the EU can do many things, but it cannot arrest you. Perhaps instead we're moving towards that stage, but also in that operational perspective, what I was curious listening to the presentation is, how is this broader and deeper scope of operational powers really affecting how national bureaucracies work from your research? Because I can imagine that there are a lot of bureaucratic hidden hurdles to this, beyond even the mere issue of absorbing the chain of command and of responsibility, which from a criminal law perspective and administrative accountability needs to be there. Then moving to perhaps if I can shift, moving to the presentation, the last presentation on criminal justice, I thought that this was very interesting because, of course, we are seeing now the new European public prosecutor who is traveling around the member states of the EU in establishing bilateral relations with all the member states. And what we have seen coming back again is the old rationale of protecting and securing EU and citizens' interests there. And what is really formidable in this regard is that the rationale and the collective problem behind it seem to suggest that also in the area of freedom, security, and justice, the spillover effect of European integration is unstoppable to some extent. And then how much can this happen without having to update the constitutional clauses on transfer of sovereign powers to the EU can hold this expansion and this deepening of EU criminal justice influence, direct influence. And last but not least, I think that I want to close with the presentation of Professor Panebianco, because as I said, from the beginning, there was a lot of criticism for the lack of humanism in AFSJ policies. And it's a criticism that is still valid today, and that in general aspects, we have seen recently, of course, with the so-called refugee crisis or the migratory crisis in the EU. And this has always been related to the dominance of the executives. And what I think that the presentation revealed, and that is so interesting, is that we may see truly a divide from institutions. So the Commission, like traditionally we assume the European Parliament, being the promoter of a different AFSJ strategy and policy beyond the desiderata, so to say, of the European Council and the member states. And what is interesting is to see is this is really a turning point in the ways in which the Commission manages to bring forward its agenda on migration, making sure that this humanitarian aspect, the consciousness that Dora Costa-Copulo wrote about also many years ago about the FSJ, is actually implemented and brought into effect. Very interesting things. I think I have said enough for the time being, trying to bring things together, and I would rather have questions coming up.
Thank you, Claudio. I think I will give you now a couple of minutes for you to absorb Claudio's comments, and I will allow the audience to make a first round of questions. We will allow everyone to put the questions live. So I saw that Raphael Bossong and also Florian Trauner, they have questions. So feel free to turn on your microphones. Please, Raphael, you first, and you can put your question. Raphael, are you there?
Now I got the sort of pop-up window that yeah. Okay, sorry. Thank you. Well, actually, Claudio already sort of riffed a lot about what I was also wondering, namely those always alluded to Articles 4 and 72, that we kind of, I mean, I at least am guilty of just playing too briefly and then never really doing the detailed work of dissecting exactly what and what couldn't be accommodated in them. So probably I should read your book, David. That sounds very interesting what you outlined, but all the others. But maybe just to elaborate a little bit, not to take too much time. So in Article 88 in Europol, we have an explicit phrase to say it shouldn't take coercive measures. On all other articles, we don't have an explicit case of coercive measures. For example, in border, it doesn't say. Whereas in Article 4, we say it shall respect law and order, but national security is sole competence. So, I mean, of course, it's all interpretation, yeah, but maybe you have a bit more to say when would be the Rubicon, like really, to say we move into a different paradigm where a treaty change would be sort of necessary. And maybe that also relates to your distinction between operational and enforcement, because I think a lot of the operational push or the expansion of agencies is not only, say, in general about protection, but also in particular in Frontex, but not only in Frontex, in relation to, well, the doubt that there is loyal cooperation, right? So we do need enforcement on the ground because the member states don't do it. So I think that would just be interesting here to hear your line drawing here. Maybe just a quick last point on Jacob. But also this Anna, if you have a point on Frontex there, Jacob, just as in the end, you kind of said cautiously, this would be a bold argument to say transnational crime. Of course, it was very short. But just to add on to what I just said, what drives the expansion of agencies? Of course, I think legal purists would say there have to be a transnational dimension to crimes or risks for agencies to take action. However, it seems to me that the argument goes in the direction that there just has to be a transnational element. And what I mean by this is, like, say, look at the argument for e-evidence. I don't know whether you looked at this dossier, right? So you can have a crime that happens only within one member state, but the data that is related to that may be stored somebody completely else. So the crime isn't transnational, but the data may be somewhere else, and there you have a transnational element which legitimizes EU involvement. This is not the same for agency, but I think in general, this is the direction it goes. I mean, also for Europol to be called in for assistance, maybe the crime is purely national, but there is an element to it that maybe only with the assistance of Europol can be addressed. So do you think that would run counter to your argument, or would you still go along with that? Thank you.
Florian, if you want, we put your question live and then they answer. Yeah.
Okay, right now I see hello from my side as well. Very interesting inputs. I have just a small question kind of to David in particular, but you're so much into the topic. There were some media reports recently that this whole package would be kind of dissolved. And I'm just wondering, do you know anything about, do you consider it realistic so that they can move ahead with the asylum agency, or is this something just a normal discussion with your assessment? Thanks.
Anne, you may start with the comment. We'll go with the alignment. Yes.
There we go. Yes, so to start with Claudio's questions about whether there are any concerns about Frontex gaining more operational powers, I would argue that there is, because as I also said in my presentation, there are not sufficient accountability mechanisms in place now. As you probably know, part of the regulation it was for Frontex to hire these 40 human rights monitors, and I think they only hired a couple so far. And also, it's very, very difficult to detangle when it's a host member state responsibility or Frontex responsibility. And I think that's just going to be even more complicated now with EU border guards also having executive powers. I think that's it. Yeah.
Thank you. David?
Thank you, Joana. Yeah, I will go straight to the question of Rafael. Very interesting indeed. So in one of the chapters, what I do is try to balance the limitations that the treaties establish in terms of conferring more, or enforcing the operational tasks to these agencies If we think about Frontex, for instance, the basis for reinforcing Frontex is Article 77, Section 2, Paragraph D, that very openly says the EU shall move towards a gradual establishment of an integrated management system for external borders. So in those terms, almost everything fits. However, if you look at Article 4 of the Treaty of the European Union, Article 72, Article 73, basically they state that the member states are ultimately responsible for their own internal security. Even if we look at Article 88 of the Treaty of Functioning, that is one of the very few that refer to an agency specifically in the treaties, in reference to Europol, it says that no operational activity without the consent of the member states and coercive measures are exclusive competence of the member states. So we could interpret this for Frontex as well. I think the way to solve this, and it will be the same thing, we could do the same analysis for EASO, but I'm not going to stop there for the sake of time. I think what we have to think, and I will link this to the question of Professor Matera, is that we have to remember that behind the transformation, the reinforcement of Frontex, EASO, or Europol, the member states, they play a very important role. And we see it when we read the regulation of Frontex, for instance. It's written in a very open and vague way. But this is not, this is intentional. The states are behind. They want to have enough room of maneuver. Why? Because we're talking about core sovereign tasks that might affect the states. With the crisis in Ceuta, many people ask me, so why is Frontex not being deployed? Why is Frontex not being called by Spain? Well, you know, because Spain wants to handle this crisis with Morocco, not having the interference of Frontex. Could they call Frontex? Of course. Could they explore the opportunity of establishing a hotspot in Ceuta or a hotspot in the Canary Islands? Of course. But Spain does not want to have the involvement of Frontex. We always have to remember the states are behind these competences that are shared between the states and the agencies. And if I may, Joana, will answer directly to Professor Trauner's question, that it was basically about the package of asylum, the asylum package. I think here it's very important to see that Frontex has been transformed twice since the refugee crisis, in 2016 and in 2019. So we are moving towards protection, securitization of the borders. However, in terms of EASO since 2010 has not been transformed. I mean, they tried to do it in 2016, but we're in 2021 and the transformation has not been ensured yet. So the priorities of the Union and the states are different. No problem about agreeing in record time to transform an agency that focuses on securitization, but rather when we're talking about protection, well, the states and the Union are not so willing to do so. And then we have to see Italy, Spain, Greece, they're basically saying, no, we want the whole asylum package to be adopted. Of course. I mean, if we think about the main problem that we have is that asylum seekers are forced, according to the current system, to apply for asylum in the first country that they reach. And this is obviously Spain, Italy, and Greece. And what they want these countries is like, no. Let's not transform EASO yet. Let's transform the whole asylum package. Because we're way more interested in transforming this rule that does not work, that we have the obligation to handle all the different applications of asylum seekers when they want to go to Germany, to France, and we have that obligation. And that is creating also a problem of migrant smuggling. Why? Because the migrants don't want to stay in Greece. What they want is to finally go to Germany, for instance, and they claim for asylum. So I would say that we're not going to see the asylum package adopted yet. And I wouldn't say that it's a key priority right now to transform EASO into the European Union Agency for Asylum. So we'll have to see and wait, but we've been waiting since 2016. So I don't think they're going to mind to wait 2 more years. I don't know.
Stefania.
Yes, Joana. I would like to thank very much Claudio for his comment, and he has for sure picked one of the research questions that I've been working on since quite some time now. I was even at the time of the so-called migration crisis suggesting that the European Union in a way acts as a schizophrenic actor, because when in 2015 we had Federica Mogherini in tears in front of the United Nations General Assembly, claiming for sharing the burden and common responsibility. And then we remember that, and this was, okay, Federica Mogherini, High Representative, the European Commission reacts with the European migration agenda. And then again, what happens to member states, in particular the visitor countries, but also I would stress President Tusk, they go in another direction. Member states and Tusk go in the direction of defending the borders, defending the EU member states' interests. And this is not a discourse that I have intercepted with my research, because my discursive analysis identifies that in the European Commission discourse, there is no securitization. We are in IR, when dealing with migration in the Mediterranean, we are thinking in terms of securing the borders, closing the borders. Former minister, Italian minister Matteo Salvini has for some months conducted the close the ports. That is to say, close the European Union borders, not just Italian borders. The strategy of closing the ports pursued by Matteo Salvini does not correspond to an approach of the European Commission, because the European Commission suggests to manage the borders, not to close the borders, which is, I would say, quite different. And the idea is that, I am quoting, it is important to make sure that there are no pushbacks at the borders. Then what the EU member states do, they pick in the new migration pact on asylum and migration, the return instrument, and they invest on returning migrants back to their origin countries. Well, there are different instruments in order to protect migrants. NGOs have experienced the humanitarian corridors. And then there is Timmermans, when he was vice president of the European Commission in 2016, I think, who was very much fond of the idea of humanitarian corridors. And now humanitarian corridors seems to have remained out of the new pact on migration. But I mean, we might discuss among us on these dichotomic visions of EU institutions for quite some time. The important thing for the time being is that I have zoomed on a different approach, specific, clear approach of the European Commission. Thank you so much.
Jacob. And then I of course, as Claudio did the horrible task of being the discussant and the panelist, if you have questions for Claudio, please address them after Jacob, of course. Jacob.
Yes, so I think I got a question for Rafael, at least that was what I remember from this. So the transnational element, I think that I'm just starting to work out this theory on when should EU intervene generally in terms of criminal law. But I do think that also in terms of like this kind of case where you have, it's an internal crime, but the evidence can be collected somewhere else, you still have a transnational element, which is pretty clear. So I think it makes a lot of sense in terms of expertise and resources to have an EU agency involved and also have binding powers in this area. So I think there is a good case also for having Europol involved in this kind of situations as well. I'm not sure exactly where to draw the border. I'm actually working on this right now to kind of like really find a perfect like balance. But I think there's a good case here as well to be made. Do you want me, Joana, to take Chris' questions as well on Europol?
Yes.
Yeah, I take Chris' questions as well. So Chris had a question on turning Europol into, well, maybe turn Europol into EU's own intelligence agency. It's a very kind of like revolutionary idea. I see that for this to work, and politically, I think it needs to have quite a lot of like legitimacy in terms like the member states actually agreeing to developing this. So I think it needs to still to have this kind of like strong connection to transnational crime, and preferably organized crime, to make sure that this actually works politically. I think it's unlikely. I'm not sure if it's that the Europol would turn itself into like its own sort of intelligence agency, but I do think that Europol should have binding powers in this area to take decisions where to kind of collect evidence, how to collect information, when to start specific investigations. I think that's actually something we have to consider. It's difficult with the current constitutional framework, as Claudio said, to have those powers on the current treaties. They need to be reformed in a way if that's going to work. Did Chris have any more questions? I forgot about now. See if you had something else here. He had also, if the EU need to build an extradition agreement at supranational level rather than bilaterally. Yeah, well, that's really beyond my expertise. I'll pass that on to someone who would know that better than me. That was a difficult question. If Claudio wants to respond to that.
Well, at the moment, we don't have a clear cutoff distribution of tasks between should they all be supranational or not. But we found, as I said, another way of dealing with that, and namely the EU concludes an umbrella agreement. We have that with the US and with Japan. We can discuss over the successful strategy there because there are not so many extraditions needed from Japan, but I guess as a playing field in which to experiment with policy, we have these two agreements where with different clauses, the EU tries to set the framework and standardization of extradition policy with the US. And then there are clauses empowering or regulating the relationship with bilateral agreements between the member states and the US. Now, the one with the US is very difficult to analyze. It's the only real extradition agreement that the US concluded, and it safeguards national clauses. So it's an umbrella agreement that doesn't really substitute, but integrates the national role. But considering how the EU has harmonized the standards of extradition or surrendering, I should say, within the member states, from a relationship between internal and external, I wouldn't see a problem with that at all. The EU taking the lead and then delegating the enforcement bilateral agreement to member states.
Thank you, Claudio. So we have now only 4 minutes. I will give 1 minute to all of you because we are running out of time. Just for your last thoughts, I will already thank you for this amazing, fantastic panel. I had many questions, especially to Stefania, that we can later discuss. So I will give the floor now to Jacob, and we will go on the other way around. Jacob, please.
No, I just wanted to bring up that when I listened to David's presentation on integrated sort of administration, integrated like EU agencies in administration, and I think that we can also see a sort of more, I think this is what I saw with David, that we have very common like findings, that we can see also an integrated EU criminal law as well, and more integrated EU criminal justice agencies, that we can see this development as well in terms of how, and I think it's an unstoppable sort of wave that Claudio was talking about. It's unstoppable that this spillover comes, because we see that these agencies can actually also make positive contribution as well to the fight against at least transnational organized crime. So that's my final words.
Claudio.
Yeah, well, also my 1 minute. I think that the challenge ahead is really understanding what the EU can do when creating these integrated mechanisms, what the EU can do when it comes or it clashes against national bureaucratic systems related to criminal justice, the regulatory framework on the exercise of the judicial function, of the police function, because inevitably you cannot integrate operational tasks unless you also influence the design. And I think that the challenge ahead is to look at what spaces are left for member states into this process.
Stefania.
Yes, Joanna. I think that the title that you have given to this session is perfectly acute and zooms on the real challenges for today, which are the challenges after Lisbon. I think that if we want to understand what's going on, why we are in a way in a mess currently dealing with migration policy, is that because in the Lisbon Treaty, some areas have been apparently turned into supranational dimension, but in truth, EU member states, starting with the exits, have been empowered. And then may I conclude that what we have assisted with the so-called Sofagate was not just a problem of gender, but it was a problem of institutions. Which is an institution that counts more when dealing with third countries? Is it the European Commission, or is it the Council, or the European Council, or the European Union? This is what we assisted in Turkey, actually. Yeah. And that's my last comment. Thanks again, and congratulations for the event.
Thank you. David.
Well, 1 minute. I'll say we need to bear in mind that we are in the area of freedom, security, and justice. These are not agencies like any other agencies. Why? Because these agencies may touch upon the fundamental rights of individuals and also the core sovereign tasks of the states. And therefore, I think we have to think a little bit more about accountability, controls, whether we have enough administrative redress, transparency. We think about FRONTEX, the whole situation with the pushbacks. So there's a lot to still think about. I'm all for more European integration, but I think that, of course, that European integration and the trust of the states on this integration needs to come hands on hands with transparency, accountability, controls. That will be my final word. And as Stefania said, thank you very much again for this incredible event.
For my 1 minute, I would just say that, yeah, since the migration crisis, we've seen a lot of development within this area, but as the new report by the European Court of Auditors on FRONTEX just established, this development has gone really, really fast. And there are a lot of things that haven't really been thought through, which in practice just has had the result that we are having a lot of expectations for FRONTEX to help the member states within this area, but in reality, it's still very difficult for them because, for instance, just some in the other panel, there is this talk about the intelligence and information, and that's still an area that's where more development needs to happen if FRONTEX is to take on this new role, and the same with accountability mechanisms.
So we have come to an end. Thank you so much for coming and for such an insightful and mind-blowing panel. So many questions still no answered, and obviously the challenges after Lisbon, I think, are here to come still. So thank you. The next panel is at 2:45. So I invite you all to take part if you have time, and of course to the next 2 days.